In the Senate, Senate Bill 1325 by Judiciary and Rules Committee, an act relating to the Uniform Public Expression Protection Act, to provide a short title, to define...
Mr. President.
Senator Lenny.
I ask unanimous consent that further reading of Senate Bill 1325 be dispensed with, and the journal show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Without objection, Senator Lenny, you're recognized to open the debate.
Thank you, Mr. President. I want everybody here to imagine spending 18 months tied up in a court and spending $20,000 on legal fees because of a blog post you wrote that someone didn't like. Or imagine taking out a home equity line of credit to pay legal fees because you're being buried in a lawsuit where the other side has seemingly endless amounts of money, or something that probably some of us have experienced in this room, being threatened with a lawsuit just for speaking up at something like a city council or a school board meeting, that type of thing. These types of lawsuits are called SLAPP lawsuits. Now, SLAPP stands for Strategic Lawsuit Against Public Participation, and the key word there in SLAPP is strategic. Strategic. These lawsuits can tie someone up for years, several years, in fact. They can cost tens of thousands. For the really bad ones, you can be tied up in court, and that could cost over $100,000, because these lawsuits are not designed to win. The point of these is not to win. The point of these lawsuits that we're talking about, these SLAPP lawsuits, are to intimidate, to distract, to bankrupt, or to punish free speech. And they typically revolve around things like defamation, slander, being a public nuisance, things like that. So with a SLAPP lawsuit, the punishment is the process. The process is the punishment. You could say it either way. These are websites that are targeted and they're strategic. So Senate Bill 1325, which we're debating right now, it's a free speech protection bill that provides a comprehensive, efficient framework for the resolution of SLAPP lawsuits. Now, Idaho is currently one of 18 states with zero protection. Zero. There's 32 states that have some type of anti-SLAPP protection. Idaho has none, which makes it also, as a result of that, a target for litigation tourism. Some people might want to have a lawsuit in Idaho because they know they can get away with it, where other states they can't. Now, I know what you're all thinking, because somebody told me this. You're not a lawyer. Why do you have some legal lawsuit bill? I'm not a lawyer, but I didn't come up with this idea or come up with this bill. This is a Uniform Law Commission bill that hundreds of lawyers spent about 3 years on before they released it as a model bill. Obviously, I think most of us know that Idaho's passed several Uniform Law Commission bills. This is just another bill that was poured over and dissected and edited and modified by tons of lawyers before I ever set eyes on it. This same type of bill has passed in a lot of our neighboring states like Utah, Washington. It's being considered all over the nation right now because it's a good law, and it has a wide range of support from people on the far left to people on the far right. Organizations and individuals have all come together, many of them organizations, to support this exact type of bill, because free speech isn't a political issue. Free speech is the heart of a representative republic. Now, that's all well and good, but you're probably wondering what this bill does. How does it expedite lawsuits? And I want to emphasize that this bill creates a process. It's not really a policy bill. It doesn't change what the judge does. It doesn't change what lawyers do. It doesn't change the definition of defamation or slander. It creates a process for the courts to use when it's necessary. So I provided you a lot of documentation. I have the legal version of the process for the lawyers in the room, and then the non-lawyer version that you probably all saw on your desk there. Here's what it looks like when a SLAPP lawsuit is brought to court. Here's what this bill does. So there's essentially 3 phases. Phase 1 is a special motion for expedited relief. Essentially, you show up in court, you're being sued for something that was maybe a defamation suit that you and your lawyer don't believe was defamation. Your lawyer can file an anti-SLAPP motion, which essentially puts a pause on the case and it puts a stay on the case. So your lawyer can say, hey, time out. Before we go any further, before we spend tens of thousands of dollars or years or months in court, before we go through a full discovery phase, and discovery is where a lot of the time and money gets spent in lawsuits, let's put a pause and let's see if this is a lawsuit. Let's see if this is even has any merit. So it puts a pause on the case. Phase 2 determines if this case has any merit, on its face. And this is where the one who brought the lawsuit, the person who's doing the suing, who brought the lawsuit in the first place, they have to show that they have a basic case for each essential element of the claim. So if they come with, let's say, 5 claims against the defendant, they did this, and this, they have to show just prima facie, they just have to show on the face value that they have evidence and merit for each of these. And then if they pass that, it goes on to phase 3, which has to do with legal viability. And this is where the burden is shifted back to the person being sued to show why they think this is a sham lawsuit in the first place. So there's diagrams there, and there's a lot of legal things here. But at the end of the day, you have to know that what this does is it expedites sham lawsuits in weeks and months instead of keeping Idahoans tied up in courts for months and years due to free speech. It has a lot of support. I ran this by the I worked with the Supreme Court on this, the Uniform Law Commission. I ran it up all the flagpoles that I thought were relevant. And with that, Mr. President, debate is open.
Is there further debate? Is there further debate? Hearing none?
Mr. President,
Senator Hart,
debate in favor of the bill?
you have the floor.
Thank you, Mr. President. This body has great expertise because we come from all sorts of different walks of life and different life experiences. And I think one of the things that makes us better legislators is to experience some of the things that we're dealing with in legislation. And I had the experience of having these lawsuits to deal with. And I think that the antidote for bad speech is not a lawsuit to shut that speech down, but the antidote for bad speech is more speech. And so this provides an opportunity to keep the dialogue that needs to be in the public square and not in the courts. The courts are for controversies that the courts have the expertise to resolve. They're not for controversies that belong in the public square, and the court should not be used to shut down that speech. But another thing I don't think we've heard on this legislation yet is that the courts are clogged up. The judges have too many cases. The courts are too slow to respond. And these types of lawsuits clog up the courts. So I think this is an excellent piece of legislation to free up the courts so the courts can do what they're supposed to do and not to be doing, policing of the public square. And so I think this is a good bill. I recommend that we support it. Thank you, Mr. President.
Thank you. Is there further debate?
Mr. President,
Senator Van Orden.
thank you. Would the good gentleman stand for question?
Senator Lenny, will you yield to a question?
Yeah.
Senator yields.
Thank you. I'm just wondering if there's, usually we're trying to solve a problem that is in the state of Idaho. Is there case law that this is, are we trying to look at something that's happened in the state of Idaho, a case, or something that's happened in the state of Idaho to solve?
Senator Lenny.
Thank you, Mr. President. So a few things is there were, I not going to break the rule of referring back to committee, but there were stories brought up, people who have been involved in lawsuits. This isn't about like a case or one case. This is about, so I can't really answer the question without referring back to it. But yeah, this does solve a problem. These types of lawsuits are actively happening in Idaho as we speak. So I'm not going to comment on a specific case.
Thank you.
Is there further debate?
Mr. President,
Senator Ricks,
to do debate against the bill.
you have the floor.
Senators, there's no question that the concept behind this bill is good, to prevent lawsuits and to limit how much somebody can keep going after another person. But I'm really alarmed that one of the fellows who testified in committee later on the same day went online.
Senator Ricks, remember how he danced around not saying what happened
Yes.
in committee? That applies to you as well.
Okay. But I am concerned about some public figures who support this concept, this bill, have gone out on social media and gone after others who testified in the committee the same day. So it leads me to have concern about whether there's something in this bill that's not true, that could be a problem, because it evidently is not stopping some of those who are real bold going out after others. So I have concerns, and maybe I do recommend that we might look at taking time to consider this, to look at things that quite likely would override our current existing laws and create new conditions where new case law would have to come forth and be tried and tested out in our courts. But with that, I do not support this. Thank you.
Thank you. Is there further debate?
Mr. Chairman.
Senator Lee,
Thank you, Mr. Chairman, to debate against the bill.
you have the floor.
Again, I also think that there are some necessary corrections to be made. It's interesting over the many years that I've been in this body that there's been a lot of resistance to the Uniform Law Commission. So to see that the Uniform Law Commission as model legislation is being brought as the perfect example in this case, I think we've come full circle. I would offer that while that is model legislation, and we've heard about model legislation for the American Bar Association or the American Medical Association, this might be partially a solution, but we have case law in Idaho, and this will change it. Perhaps it needs to be done. I would offer, though, that this is a big idea that needs a little bit of time to work through our process to ensure that all of our civil rules of procedure, if we are going to change some of them and put some of them in this piece of legislation, we need to make sure that we are putting all of those in. And there is reference to appeal, but not all of the civil rules of procedure are put in this statute. And if we want those to be in this statute, let's put them in this statute. So, again, this is model legislation that might be perfect for other states. I would offer that Idaho needs an Idaho solution, and we need more time for this. And I would urge you to vote against this particular piece of legislation.
Senator Groh, you'll be recognized as present. You're always welcome. Is there further debate? Hearing none. Senator Lanny, will you stand and close the debate, please?
My pleasure, Mr. President. Thank you. Just to address a couple things, Senator from 34 brought up that somebody testified who he wasn't a big fan of. That doesn't really have anything to do with the bill. And there was, we also heard debate saying that this would override case law, that this will change how case laws work, and that's, yeah, it will. That's the point of the bill, to change how things work. This bill, again, creates a process. That's all it does. It just creates a new process to use in the courts. It's like putting a new tool in the judge's tool belts and the lawyer's tool belts that they can use when they want to use it. What this bill does not do is take away anybody's job in a trial. Lawyers still have to present their case. Judges still get to be judges. Appeals can still happen. What this bill also does not do that was implied during debate is this bill does not give anyone a hall pass to engage in defamation or slander. If you're defaming or slandering someone, then you should be held accountable for that, and you will be held accountable for that in the courts. What this bill does is it creates a process to let good lawsuits continue and go through till the end, and it stops the bad ones from getting traction up front. So Idahoans who are being punished and targeted because of their free speech don't have a six-figure lawyer's fee to pay, or several months or years being tied up in court. So this acts as a deterrent so that the courts won't be clogged up and people will hopefully not bring those types of lawsuits anyway, knowing that it could get shut down on the front end. Again, senators, this is a free speech protection bill, and I ask for your yes vote. Thank you.
Thank you, Senator. Debate is closed. The question before the Senate is, shall Senate Bill 1325 pass? The Secretary will poll the members.
Adams.
Mr. President,
Senator Adams,
I would like
you
to...
have 60 seconds to explain your vote.
Thank you, Mr. President. Every time that every year when we come back here, we hear from the judges in the courts. We hear about how they... we hear about how their caseload is heavy and they need additional funding. And sitting on I am currently the floor sponsor for the judicial budget, and it is indeed growing. If this alleviates some of that backlog, then I'm all about it. It may end up saving us, the state, some money as well. Thank you, Mr. President. Senator votes aye.
Senator Adams votes yes.
Anthon. No. Berndt. No. Bierke. Aye. Burtonshaw. Aye. Cook. Den Hartog. Aye. Foreman. Aye. Forsman. Aye. Grow. Guthrie. No. Harris. No. Hart. Yes. Hartkin. No. Herndon.
President, 60 seconds.
Senator Herndon, under Senate rule, you have 60 seconds.
Senators, I'm going to tell you my secret to being a decent senator, and that is that I have a terrible memory of who wronged me. And I've done a lot of research looking at Cornell Law School and others about the anti-SLAPP lawsuits, and I think the policy change here, the structure, is a good change for Idaho. It will save costs. It'll keep people out of court. It'll preserve free speech regardless of parties or even the Uniform Law Commission. The senator votes aye.
Senator Herndon votes yes.
Just. Lakey. Aye. Lee. No. Lenny. Yes. Lent. No. Mosier. No. Nichols.
60 seconds, Mr. President.
Senator Nichols, you have 60 seconds.
Thank you, Mr. President. I got to listen to the hearing of this bill, and what I really appreciated was all the different groups, the due diligence that was done in getting people together on all sorts of different sides, different backgrounds, and also those that are the professionals that have to deal with these sorts of cases. We always ask when we're trying to run bills, did we go to the people that this is going to affect? Did we talk to the people that we need to talk to make sure that this is going to work as a bill? And I think that is what was done here. I think this is definitely going to save costs to the people in Idaho. I know several people that have been in similar situations that have had to deal with this, and it is quite expensive and it does a lot of damage to them in the long run. So if we can avoid that by having an off-ramp before things get too far down the road, then that is the way that we need to take this, and the senator votes aye.
Senator Nichols votes yes.
Okonowitz, Robbie, Ricks, Ruckte, Schroeder, Taylor, Taves, Trakel, Van Orden, Ward Engelking, Winder, Wintrow, Zeiderveld, Grow, Just, Robbie, Taylor,
The vote count shows 15 in favor with 20 against, fewer than a majority having voted in the affirmative. Senate Bill 1325 has failed to pass the Senate. It will be retained in the office of the Secretary.